Great. Good morning, everyone. Welcome to House Healthcare. It's Friday, March 17th, St. Patty's Day, which is great. And we have with us this morning the Chair of Judiciary, Martin Lalone, who's going to walk through H230 and the changes they made. We'll then take a straw vote on those changes. So I'm going to turn it over to Martin.
Thank you.
Sorry, let me just say it's also posted. You're not going to share it, but it is posted on our page, just so everyone knows.
Yes, perfect. Martin Lalone, representative from South Burlington and chair of the Judiciary Committee. And we're looking at this is actually our committee report, actually. And it's...
You want my iPad?
I have it right here.
Okay.
I have it right here.
Okay.
So I'll walk through relatively high level. There's a couple points I'll focus in a little bit more, but a lot of the language is kind of some tweaks to make things a little clearer. But starting out, we do have, so judiciary has somewhat different, well, very different jurisdiction than healthcare. And one of our areas of jurisdiction is public safety, which in fact does also include suicide prevention, though, that's from the criminal side of people providing firearms to individuals who might use them to do harm to themselves. It's not the public health component of it, which you guys are the experts on. But on public safety, we heard during testimony some other areas where these policies would actually assist in public safety. And that's what these additional findings, except for the first one, which also talks about suicide prevention, findings 9 through 12 really focus on straw purchases where somebody will go, somebody from out of state usually will be in Vermont, a drug dealer, and they will get somebody who has a clean record but is dependent on drugs to go to a store and purchase a firearm. And they give them money, they purchase the firearm, there's no waiting period, they have a clear record, and they trade the drugs for the firearms. And that's what these findings of fact really relate to, that a waiting period, as the state's attorneys told us, would be very helpful for preventing those kind of transactions, which happen a lot. Rutland particularly, is my understanding, is one of the areas, and places closer to the border. So that's what those reflect. So moving on, and if anybody can stop me with questions at any point if you have questions on any items. Moving on to page 4, that's just grammatical, just to make that particular provision clearer. Moving on to page 5. So we did some restructuring, although the exceptions that healthcare had remain, but they are somewhat changed, and the structure's changed a little bit. The exception number 2, we needed to reword a little bit, because just saying under the control, we had testimony from the court, from state's attorneys, from defender generals, that was ambiguous, and we needed to expel that out a little bit closer. So we used the language from the Connecticut safe storage law, and that's what that reflects on subsection 2.
Now, does that mean a person can have a firearm beside his bed for protection at night?
Right. Yeah, that's what that would mean if it's in close proximity.
Okay.
That's correct.
All right.
And
with loaded.
Yeah, I mean, that is correct. Yeah. Mm-hmm. Yep. So that's correct.
Okay.
That is an exception. And I mean, arguably that would have fallen under the control, but that's not, this makes this clear. This clarifies that. So the other exceptions really were not like, it was more of an exception to the violation, that this conduct is not a violation. It doesn't really significantly change things, but a child or prohibited person accessing the firearm as a result of an illegal entry, that's really not an exception to whether it was safely stored or not. It's exception to whether there's a violation. It's nuanced, but we live in nuances in the Judiciary Committee. Probably one of the biggest changes, well, there's a couple big changes here. One of them is that we did strike the fine only. And this was not actually a civil fine. This is the way this whole thing is worded, is it's a criminal offense, fine only criminal offense. But this is one of the areas that we had during testimony, had probably most of the concerns and pushback. Besides the whole bill, and some people didn't like any of it, but it's difficult to enforce. There's a very strong, as you all probably know, in Vermont, libertarian streak, no matter which party you're in, and privacy protection. And this raises the question of privacy protection, concerns, perceptions, I would say, because I don't think this actually would happen, that law enforcement are going to get warrants to look into houses to see if firearms are not safely, securely, are not secured. So most of the folks in the committee wanted to take that out. And we really did a lot of work, frankly, on this section, trying to get it right. And we tried several things, and I will not go through all the different machinations that we had. But this is where we finally settled on, is really thinking we should strike that out. The subsection C that you see, that, I'm sorry, that I'm moving back up. That's language that you did not have. We had for a little bit. That was part of our kind of trying to figure this out, and eliminated that because that was way too broad. We were trying to figure out a way to narrow that, but I won't go into what we ended up not doing, but that language is still there and it will be gone by the time we have a final version. Let's see. So the other fairly big change from what you folks sent us was your definition of injury. And in the subsection, or subdivision, I should say, B2, we changed from injury to serious bodily injury. And then you will see, and I'm going to skip ahead. It's on page 7, which is the definition of serious bodily injury. And you will note that we did strike the definition that you folks had of injury. And I will explain why that is. The main reason why we felt that we had to strike that is it is a very broad definition of injury.
The one we had originally.
The one that you have. I don't disagree that is injuries, but that's not the kind of injuries that we see in criminal law. We see either serious bodily injury or bodily injury. And we considered moving to bodily injury, which you can find the definition in 13 VSA 1021. And bodily injury means physical pain, illness, or any impairment of physical condition. And serious bodily injury means bodily injury that creates any of the following: a substantial risk of death, a substantial loss or impairment of the function of any bodily member or organ, a substantial impairment of health, or substantial disfigurement. Law enforcement, state's attorneys they know how these different definitions work. And in bringing in this very broad definition was problematic for that purpose because it was fairly kind of vague in some respects. But more importantly, the bodily injury definition that I read, you will find that in our offenses for misdemeanors, for like 1 year misdemeanors. And this definition is going to a 5-year felony. And we match up the extent of injury relevant to the penalty that's imposed. I think it's important to have the 5-year felony to make it very, we're very serious about this, but it really shouldn't be attached to a type of injury that's very broad and not even recognized right now in criminal law, or to one that is associated with misdemeanors. So that's why we went to serious bodily injury. So back on page 6, we changed the shall to may, and that was at the request of state's attorneys. And we're talking about charging discretion, and we want to have them continue discretion. There was pushback of even having that provision in there because it was kind of of course we do that. And it's, almost, you're impugning us for even suggesting that you need to tell us that. But so we said, well, I'm going to change it to may. Does that help your feelings? That's not how I put it, actually. That is not how I put it. But so, and that was an important, I think that was an important change for them. All right, let's see. On page 7, at the top, there's another change, and that is really just grammatical as well. So I will jump past that. We have a definition of authorized user, and that goes back actually to the exceptions on page 5. I'm trying to find where authorized user is. I know there was an authorized user that, bear with me. Yeah, okay, yeah, it's the exception as far as within the control. There was a concern raised by various witnesses, Defender General's office, state's attorney, that needed a definition. So we provided definition. I don't know if I necessarily agreed, but to make the Defender General's office happy, we put that in.
So does that mean that a person under 18 is an unauthorized user?
18 years of age or older who is not a prohibited person who has been authorized to carry or use the firearm by the owner. That in the context of safe storage and in context of the exception, yes. There can be other contexts where somebody under 18 is an authorized user. I mean, they can have their hunting rifle. They can go out. If it's not in the context that it was, that it has to be safely stored in the house. If there are children or prohibited persons that can gather or can go to it. I don't know if that really explained it. I apologize. So, okay, so moving ahead. So we had a relatively, you'll see a lot of yellow on the, I'm sorry, page 8, 8, 9, 10, and 11. I kind of will talk about that as an entirety first. This is the ERPO section, and we had testimony from the Chief Superior Judge and from state's attorneys and from Defender Generals and from others raising concerns about allowing or having household members be able to apply for ERPOs. And one of the concerns was the way we had the definition of household member tying to 15 VSA section 1101, which that particular provision and definition can mean a person who are living together or who have ever lived together or who have ever dated. And, somebody who dated 6 years ago, you don't want them to be able to bring this. So we changed the definition slightly so it's present tense essentially. That it is occurring right now. The other thing is that, so if one seeks an ERPO, we feel that there should be quick, ready access to the process. And that's really in the ex parte motion, where it's just the one side that's coming to the court. But when you get to look for the final ERPO, it's a higher standard, it's clear and convincing evidence. By that time, you've had to have law enforcement involved anyway, and probably state's attorneys anyway, because if you get an ERPO, law enforcement has to serve it. If there has to be any kind of warrant or work for relinquishing the firearms, state's attorneys have to be involved. So this was at the suggestion. Now, first of all, the Chief Superior Judge didn't like the whole thing at all, didn't want to change this. But state's attorney made this recommendation that allow family members and household members to initiate this. So we still would want people to initiate it through law enforcement and state's attorneys, because even at that initial phase, they would have a better chance of actually having the right outcome. But nevertheless, there may be times where somebody can't really, figure out how to get to law enforcement, or, they just want to go directly to the court. It's an emergency. They need a fast reaction. We want to allow family to initiate the process. Once they do, and once they've been considered for the ex parte ERPO, or if they just seek a final ERPO, once you get to that final ERPO time, it's the state's attorney or the attorney general will essentially take over, be the party. And we felt that particularly since it was bringing the state's attorneys along, the judge was fine with that, not completely pleased, but, fine with that. And our main purpose was to make this accessible for families and households. So we went with this language. And I can go through all that language, but I think that you get the point that that's what this language does. Finally, in the section 9, which is on page 12, and 13 is the waiting period. So last year when we passed, and I'm not going to remember the number of the bill. I can barely remember the numbers this year. We passed a law that, among other things, changed the background check. If there's I don't know how much you folks have gotten into background checks, but that when somebody goes and gets a firearm, the FFL, the Federal Firearms Licensee, I think is what FFL stands for. They do a check on what's called the National Instant Background Check System, close. It's NIC system. And they do a background check, and probably 96% of the time, or the high 90% of the time, it immediately comes back and says, yes, this person is approved. A smaller percentage of the time, it comes back and says this person's not approved. They have an outstanding protective order, relief from abuse order. They're a felon. They have a order of hospitalization, et cetera. But then there's also sometimes when it's delayed, and it's called a delayed proceed. And under the federal law, after 3 days, if you haven't figured out if this person is approved or not, the firearm gets handed over or can be handed over to the purchaser. What our change last year, initially, we were eliminating that the delayed proceed in its entirety, and a person couldn't get their firearm until they were approved, until they actually got this identification back from the NIC system, this ID number. So we passed that out. The governor vetoed it because of it. There are other things in this bill, but that's the reason that he vetoed this, because we eliminated what's called the Charleston loophole. And we came back and we essentially negotiated through the veto process, which is not the best way to negotiate, but and came back with a 7-day. We extended that delay to 7 days. So the language that we received would have gone back to what was vetoed, as far as it would have gotten rid of the so-called Charleston loophole. Would love to do that, but want to honor what, where we ended up last year. So that's what this changed language in subsection A does. It means that no longer than 7 days are you going to have to wait to get your firearm, even if there's a delayed proceed.
Okay.
So last year, you had to wait, what was it, 3 days? And then you could take them.
Only if you didn't get an immediate response, which is probably 1% of the time.
3 days to 7 days here?
That's what we did last year.
Oh.
What your language did, Topper, is that it would have said you don't get your firearm until you have an approval. What we came out with last year was after 7 days, whether or not you have an approval, the firearm could be turned over. So that was, and we want to honor where we ended up last year. And so it's either if you're approved right off the bat, or if you're approved, you have a 3-day waiting period. But if you're not, it's only going to be 7 days maximum.
Which is what it is today.
Which is what it is today. Yeah. So the other thing we did, and one of the concerns that we had and was raised in testimony, is with respect to gun shows. And it's a little tougher for the 72-hour period to be applied to gun shows because they're often weekend events. It can work. It does work in some places where what happens is you go to a gun show, you find a gun, you purchase it, you get the background check there, and it's sent after the 72 hours, or maybe it's sent right away, but you have a 72-hour, 2-week, or whatever the waiting period is of the state, and it's sent to an FFL that's close to the individual. That's an additional cost of up to $100 to have that whole transaction, is my understanding. So some states, I'll give you an example, Florida. Florida has a 3-day, 72-hour waiting period. But they have an exception if at a gun show, if somebody has a concealed carry permit, which shows that they own a firearm. So if you own a firearm, you shouldn't have to wait. And we agree with that. Particularly if you own like a handgun, you shouldn't have to wait. Yes.
Hold on now.
Okay, I'm sorry. Just before I forget, you said with a concealed carry. I don't have a concealed permit, but I do own firearms, so.
Right.
You use
That's the problem that we've, identified, and there's a potential solution out there. And what we're going to look at, and I've already put in a drafting request for next year, is not going all the way to concealed carry permit, but some sort of process where we can be assured that somebody, I'm going to call it the firearm owner's ID. And I'm not looking for like a registry of everybody's firearms, but if you have some proof that you have a handgun, and this can be somehow certified, and there's ways we can do it. It's just that we couldn't figure this out in the time permitted now. So for the gun shows, we're exempting them from the 72 hours, but that gets repealed July 1st of 2024. So it gives us between now and, and next session to figure this out, or to decide that we will extend the exemption for for the gun shows. We'll figure out. I'm hoping to come up with a way that we can have a fire owner's identification that protects the privacy of the firearm owner, so that they don't have to register all their firearms, that they don't necessarily have to have. I'm trying to do as little to what Vermont has been doing for a very long time. Although, I've heard from a number of gun owners and people associated with the organizations, and by the way, I'm a gun owner as well, but actually having some sort of a permitting system can address a lot of issues that we have been trying to deal through these issues. Maybe we take a broader look, but that's my intent, is to avoid that situation where somebody has a firearm and has to wait.
So the 72 hours, gun shows is exempt right now, if this passes, until
Right.
2024.
Right. The rest is not exempt because it's a little different scenario. These stores, the FFLs are, generally available, and so.
So I have let Jill and Connor know that we may be a little late to the floor, but we do have 3 bills up for third reading. So we can't be too late. So I think Brian has some questions potentially.
I do, but honestly, I'm overwhelmed because I've just been spoken at for 25 minutes and have had no chance to read it or process it. I feel like this always happens when we do gun stuff, and I get like flooded and don't have a chance to fully understand it, and then I'm pressured to vote on something. So I want to read it before I ask you the question, because I don't want to look stupid, and I'm trying to read it while you're talking, and I can't process both.
Okay.
So it's just too much.
So we're gonna let you read.
Yeah.
We're gonna talk.
Or maybe I should go in another room and read so that I can focus.
That's fine. Just read fast. Art, and then Alan.
The piece about signage at gun shops, and,
Yeah. What is that in here?
Yeah, we haven't done anything to
Touch that.
it. We didn't touch that. So
oh, you didn't change it?
we didn't change it at all.
Okay, so that's still in the bill?
Right. Yes. Yes, it is. Yeah, that was.
Okay.
He's just telling us the changes.
Yeah. I only
All
wrote the
right.
changes. Yeah.
Oh, okay, all right, okay.
Alan.
Well, I have a comment and a question. First, a comment when you said that a lot of our guns go across state lines illegally, and a 72-hour period would work.
Right.
If they're coming over here from another state, 72 hours ain't gonna make a bit of difference, okay? So I don't think that's pertinent
Well,
to this, but
That's
it's a comment.
yeah, and that's just to reply to that comment, the testimony from the state's attorneys and law enforcement who are doing this work disagree with that.
And rightfully so, and my question is, we're making these laws, and I think I heard you say the same thing when you're saying they're supposed to be locked up, but no law enforcement's going to come in and check. Why do we keep making laws that we're not going to enforce?
Well, we took that part out because of the enforcement issue, because of the perception and privacy concerns in Vermont. But we have this other provision, which is something that we don't have in law right now, is that if the firearm is not secured and a prohibited person or a child has access to it and they then cause harm, then there's a penalty.
Okay.
So that's the part that's enforced. Something has to happen. It's not just that you have your firearm on the kitchen table. But if a child gets that and kills himself or harms others, or uses it in a threatening manner or uses it to commit a crime, there's consequences.
My last comment is, I think we started out as a suicide bill and it's turned into a gun bill. I don't think that was our intent or my intent, so that's
Right.
my problem.
Understood. I mean, I think in many respects have actually have heard various concerns from gun owners of Vermont, from the Sportsman Federation, and have moved in their direction, and others. It's not just them. For instance, the taking out the fine for that we already talked about, the gun show exemption, et cetera. So what we have done hasn't really changed any of the policies, except perhaps made them a little easier for certain constituencies to swallow, so.
Brian? Any questions?
Well, what I'm trying to figure out is it's the judiciary stuff that we don't have the experience working with. Like, did we, when you said that you changed something around injury, which was something I felt like was our jurisdiction that we spent a lot of time talking about, that is this now felonizing? Is it creating a felony instead of a misdemeanor?
So the bill that we received from you, the injury was attached to a 5-year felony. So your definition of injury, which was very broad, and I like the definition, but it shouldn't be attached to a 5-year felony.
I agree.
And there's nowhere else in here where there's injury associated. So if a firearm is taken and used for a commission of a crime, you can probably presume injury because there was a crime, whatever that injury may be, but it's the commission of the crime or the threatening manner that we're focused on, not what the ultimate injury was. Unless, of course, there's serious bodily injury and you're moved up to a felony level crime. And that's not to say that there's not that kind of injury, Brian. I absolutely understand that.
No, I'm okay with what you changed. What I was trying to understand is, did we felonize something? But it sounds like you fixed a mistake we made where we felonized something.
That was very
But still-
broad.
Yeah, which is not what I want to do.
Right.
It's still a
Yeah.
felony, but it's back
It's
to
still a felony.
still the narrow version.
But hurting someone's feelings isn't a felony now.
Correct.
That's real. And not to dismiss that, but like.
No, it doesn't.
Okay.
We did not just.
Yeah, so.
All right, this has got to be the last one.
I'm just wondering if you had considered broadening the 1-year $1,000 fine to be a little bit more inclusive than commission of a crime or displaying it.
We did, and we worked. That was the biggest issue the last couple of days of trying to work out to have that broader, but not too broad, to recognize that under 18, they have certain rights to firearms and hunting and such. It didn't work out, and we went back to this. It was just.
I'm thinking more along the lines of like a child would access it and the child's with their friend and it's discharged and they like graze their friend's arm. So.
Well, that would be a commission of a crime.
But what crime is that?
It could be reckless endangerment. It could be simple assault.
Okay.
There's a number of different crimes. And so that's the thing, that commission of a crime covers a lot.
Okay. I guess I didn't understand that.
Yeah.
All right, so we will take a straw vote. All those in favor of accepting the judiciary amendment, raise your hand. 1, 2, 3, 4, 5, 6. All those not in favor, raise your hand. 3. 6, 3, 3. Thank you, Martin.
631. 631.
Could I make a statement?
Absolutely.
Martin, I appreciate the changes that you made. I think they were good changes, I really do. But I can't vote for them, or I won't be here next time.
I was hoping for you to vote for that, not so that you wouldn't be here next time, but.
We want you here. All
Thank you.
right, everyone, we got to hurry to the floor. We have especially Bobby,
Yes.
Art, and Daisy. We can go off air.